Hello, everybody. It's Dave Neal, stand-up comic and host of Bachelor Nation News. We have some press that is making its way around the world here in the Clayton Echard paternity scandal. Let's go to it right now. Susie Evans says she never once questioned whether Clayton Echard was lying about paternity claims. Now, of course, we know this is in reference to her stint on Vile Files, which aired yesterday. Chances are how this normally works is when there's an article like this to be written, either two things could happen. Either Ryan Hudgens, who's writing the celebrity news, listens or watches to all of Nick's podcast, or Nick's people send out like a press release saying, hey, we have Susie talking about Clayton. And because no one's really covered this story, it is kind of big news to hear somebody out there in the Bachelor world supporting Clayton. I can tell you firsthand that I have messages from people that are supporting Clayton saying, I can't believe more alumni haven't supported him. And then other people have said, why should alumni support him in this cause? And my belief is that, well, because if they have looked into it and if they do believe that it's frivolous or without merit or, if they believe Clayton, if they believe him to be someone who's been telling the truth, then they would want to defend their friend. And when it's all said and done, Clayton's going to have a hard look in the mirror and see who in Bachelor Nation is truly in his inner circle. Susie Evans got candid about her thoughts on Clayton. So here's what she said. When this was happening, I heard Clayton's perspective, she said on the Vile Files podcast. And if there's one thing I can say about Clayton is that he is not a liar. He is not a perfect person, but he is not a liar. And I never once questioned him in his honesty to me as a person, human to human. That's great. Can't get sued over saying that. Now, of course, this is just good press for Vile Files. It was a perfect example of Nick being able to get clicks for his podcast without him, entering the line of fire, as it were. So let's see what Us Weekly or Us Magazine actually has to say. Clayton Echard made headlines in September when an unnamed woman claimed that the former Bachelor lead was the father of her unborn twins after a one-night stand. Echard, who alleged that the pair did not have sexual intercourse, claimed the next month that a paternity test confirmed he was not the father. So when he told me that his side of the story very early on, I was pissed. Susie says. So, of course, the article does, this is run through their legal team here. Despite Clayton's claims, the anonymous woman told Us Weekly in a statement in October that he was lying about the results. She also claimed in court documents filed on August 1st that she engaged in sexual activity with Echard on May 20th and hadn't been with anyone since March of 2022. Again, Clayton says the sexual activity they engaged in was oral sex, which, unless anyone's getting their turkey basters out for Thanksgiving season or any other form of artificial insemination, and by artificial I mean not penis in vagina, I don't know how else to put it, then this probably wouldn't lead to a pregnancy, right? Again, who knows? Clayton, for his part, alleged in court documents that the case was groundless and lacking in merit and requested to be awarded attorney's fees. As for how Echard is faring now, Evans revealed on the podcast he's okay. All right, so she said there was a period when he wasn't okay, and that, so that's the whole story. Now, how does this relate to what we're going to talk about next? Well, we've discussed the idea that there could be a pattern between Clayton's accuser, who we've referred to as Jane Doe, and past cases that she's been in. There's a case that she has had, I believe for several years now, ongoing. She has an order of protection against a man named Greg Gillespie. Greg Gillespie attended Clayton's court hearing. I believe she possibly could be trying to get him charged with violating his restraining order because he was at the court hearing, although she wasn't. And again, I believe if he was potentially a witness, maybe he would be allowed at the court hearing. I'm not entirely sure. Again, not a lawyer. I just have this trusty book given to me by a lawyer called Objections at Trial. So I've got the revised edition. Anyway, so I'm going to play for you this 20-minute clip. That's right. It's a long one. A 20-minute clip of Greg Gillespie's lawyers arguing with Jane Doe's lawyers about their court case, which is, I don't know all of the information here, so correct me anywhere in the comment section. Jane Doe was trying to prove intentional infliction of emotional distress, and Greg Gillespie's lawyer is trying to argue that there's no actual evidence that she has been intentionally inflicted with emotional distress. It's very similar to the case that Jane Doe is making against me, in which she claims that I'm responsible, or maybe it's not in the case, but she is claiming through different emails to me that I'm responsible for lost business that she has had, and that I'm responsible for emotional issues and trauma that she's faced because of my coverage of the court trials. Now, of course, we're allowed to cover these court trials. They're public. This was from, I believe, a week and a half ago. I haven't shared it yet because I haven't really known what to do with it. But after we watched the live stream of Clayton versus Jane Doe, we saw that the judge would not let any evidence of past trials in. And I'm not sure why that would be, because I believe you're allowed to talk about past trials with past people if you're trying to prove a pattern. So the question is there a pattern between things that have gone down between Jane Doe and Greg Gillespie and what's going on with Clayton? Is there a pattern? She's accused Greg Gillespie of coercing her into having an abortion. We know with Clayton, she offered to let him decide if she should get an abortion or keep the baby if they kept dating. With Greg Gillespie, he alleges that she said she was pregnant with twins. She then later said she never told him she was pregnant with twins. He hacked into her account to, change messages, whatever, to say so she goes, I never said that, you hacked into my account, right? With Clayton Echard, she claims that Greg Gillespie also hacked into her account another time to forge those ultrasound documents, which of course were revealed are 6-year-old ultrasounds, which she claimed that they were hers. She said she didn't do that at all. It was actually Greg Gillespie who on a number of occasions has hacked into her account. Why is that all important? Because we're trying to show that there could be, they say where there's smoke, sometimes there's fire. There could be patterns that are used in multiple cases, and maybe not. This was supposed to be the final case that Greg Gillespie ever had with Jane Doe, but we found out right after this case, he was hit with another lengthy police report by her, which I don't know if it's public yet, but it will become public when all is said and done, and we will continue to share that. And you might say, Dave, why are you covering a court case if it's non-Bachelor related? Well, for several reasons. One, because this is the court case that predates Clayton's court case with the same woman, and also because I'm now involved in my coverage of this. So anything that has to do with all of it, we're going to rise that up to the surface and show it with you guys, so at least in the court of public opinion, people know what I'm dealing with. It was there was a giant effort by Jane Doe to make these court cases not appear public for people to see. She had sent me, amongst other people, a bunch of letters saying this court case is sealed. You're not allowed to share the documents, which we have since found out is just not true. It is not sealed. Anyone like me could screen grab this from the public and listen to it. She sent scathing emails to different podcasters saying that if they decide to cover the story with my point of view, that she intends to sue them for defamation, which I don't believe is a reason to sue people. If people have an opinion that is parallel or reflective of my opinion, I think they're allowed to have that opinion, right, folks? Okay, so either way, let's go into it. I'm going to try to pause as little as possible. There may be some pregnant pauses in the court case between the judges and who's arguing for who. I'll try to fill in some color commentary, but anyway, let's have a listen to this court case, which involved the intentional infliction of emotional distress. And I'm going to tell you the ending already. The judge throws the case out. He says, I can't prove any of this. So no one gets any money for the legal fees. No one gets any money for punitive damages. Y'all just didn't prove your case. Have a listen.
Similar to the other cases before the court. The other case that got dismissed? No, the other cases before other courts and the Superior Court.
Well, this court dismissed the statutory claim already, correct?
Yes, Your Honor.
Okay. So, are there other statutory claims in this case?
No, Your Honor. Okay. The only claim that survives that's left is the intentional infliction of emotional distress.
I understand that.
The case law that we brought before the court states that people usually suffer emotional distress in their everyday lives. But the question is, there is the difference between emotional distress and severe emotional distress. Plaintiffs submitted various exhibits that show, a COVID test conversations between her providers, has never demonstrated or never presented any evidence to show that there is a physical manifestation of injuries.
Which is not necessary, correct?
The case law is developing that way, Your Honor. There's no published case in Arizona, but for the most part, there is an unpublished case we cited to that it states that. And it's very persuasive. It's as of 2017.
Doesn't it state that that with the manifestation, it just becomes more persuasive, but not necessarily without it, they lose?
Well, I think it has to be dealt on a case-by-case basis.
That's what it does say. I agree with that.
Yeah,
So I think what they're trying to argue is, in order to prove emotional distress, you have to show that something physical had happened. You can't just say, "Oh, I'm hurt on the inside." Like, you have to prove that, at least not in every case, but that really helps out your case.
In this case, what we have here is about 8 exhibits that do not relate to anything regarding her physical manifestation. All we have is a plaintiff saying she's been depressed, she thinks about this, the ordinary emotional distress that people would suffer on an ordinary basis. Last minute, they file an affidavit where they never disclose the development of what the distress issues were or symptoms were, and they attach photographs of some rash. There's no causal connection between this alleged rash to the conduct that Mr. Gillespie...
Was the photographs of the rash previously disclosed?
No, Your Honor. Those photographs were never disclosed. We objected to those in our reply to their controverting statement of fact, or their statement of facts. But, Your Honor, so without the physical manifestation, all we have left was the same exact thing they're arguing that Mr. Gillespie is doing.
Did they refer to the rash without the photographs previous to the motion practice?
Not that I'm aware of, Your Honor. I don't think so.
So they're saying Greg's attorneys, and again, please correct me if I'm wrong. I'm not a lawyer here. I have no zero legal background. I'm in the Hard Knocks School of Law, which is learning due to my own involvement now in this court case here. But boy, that can help you learn real quick. You think you're going to have to go to court? You crack open a book or two. Well, so Greg's lawyers here are arguing that she provided this evidence without any information to back up the dates and why she had these rashes. I mean, she could have literally, you know what I mean? Like, rashes can come from anything, you know what I mean? It's like, I got jock itch from playing volleyball with my buddies. Well, I have emotional distress. It just doesn't hold up, right? That doesn't hold up. I had the same issue with her with regards to her order of protection against me, which was denied, which I'm going to share with you guys right now, just to show this part here where the judge denied her protective order against me. And the judge had said the allegations in the petition are conclusory, not specific as to date, time, message, and potentially involve core First Amendment concerns. I share this just to show you need to provide very specific evidence when you make such lofty claims against people here. So that's where they're at right now. They're basically saying, we saw photos, we don't know where they came from, we don't really understand how this proves any damage, and let's continue.
Photographs came up literally to what I view as to create a genuine issue material fact, because we've told them, we said we need a physical manifestation of injury. So these photographs came up, but even if the court were to consider the belated disclosure of the rash.
Yeah, I just heard that sentence coming from the other side, but go ahead.
Exactly. So even if the court were to consider that, there is no causal connection between the conduct that's not before the court, because that claim's no longer there, and the physical manifestation, what she's portraying as the rash. So, Your Honor, there's no expert opinion to opine on that. You know, it could be caused by something unrelated, and which is why I asked the court to take judicial notice of these other cases, because she's been doing the same thing to other individuals, and that's public record, Your Honor.
So in that moment, we've got Greg's lawyer saying she's doing this to other individuals, says there's no causal connection between this rash, no expert opinion to opine, no one to say, I'm a dermatologist, this rash happens right here because of there's just none of that.
Right. So even if we get to the physical manifestation, which there isn't because it wasn't disclosed, but even if the court does consider that, there's no causal connection traced back to Mr. Gillespie's conduct. And again, Your Honor, the same thing they've argued in their motion, their damages calculation is computed as attorney's fees and costs of $40,000. In tort cases, we're not entitled to recover attorney's fees and costs. So I'm not sure, they're arguing the exact same thing we're arguing in our case. So for those reasons, Your Honor, summary judgment is proper for the three reasons: that there's no physical manifestation, and even if the court considers that there's absolutely no causal connection between the conduct, the alleged conduct to the physical manifestation, and more importantly, as with any plaintiff, they bear the burden of establishing their claim through a preponderance of evidence. They've attempted to, in their response, they've attempted to place that burden on us, that we didn't raise that, which is not proper. It's their burden to present their damages. They did not do so. They're not entitled to attorney's fees in tort cases. And for those three reasons, Your Honor, the summary judgment is proper.
Counsel.
Thank you, Your Honor.
Are you entitled to use that affidavit?
If it seems like they objected to it, Your Honor, it is a late disclosure. I think whatever rules the court applies to both sides should be applied to both sides. So if the court determines that it was too late of a disclosure, that's what we're left with.
And let me just bounce it back to you just for a second. Do you agree with that?
Your Honor, I was stuck with the case when I got it, but I do agree that the computation of the fraud...
He said, I was stuck with the case when I got it. So I don't even know what that means. Now, obviously, lawyers have a duty to defend their client, but I guess you could mail it in. I'm not saying the lawyer's doing that, but when he says I was stuck with the case when I got it, I wonder, because I don't know if this case was passed down to him. I'm not really sure. I'd love if anyone has any information on that.
I am not asking in any gotcha type way. I'm asking more whether there's any distinction between one later disclosure over the another, and it doesn't sound like there was, correct?
For the fraud claim, Your Honor, it wasn't disclosed, and that's what I'm saying. But so I agree.
You're in the same boat, the other direction. Okay, go right ahead.
Right. Your Honor, the only distinction I guess I would make with regards to my client's disclosure is what Mr. Zazueta noted as far as the failure to disclose any legal claim regarding physical manifestation of symptoms had to be shown. Because as I indicated in our filing, if you look at their disclosure...
but that's just a matter of what the elements of the case are. It's a legal issue. The point's taken, is well taken, but understanding the question of the legal standards, I'm not quite sure that's a legal theory, but I understand your position.
Thank you, Your Honor. And let me back up. One other thing that I just wanted to note for the court as far as the defendant's motion for summary judgment is that, so their prong is, absent a manifestation of physical symptoms, plaintiff cannot assert a claim for intentional infliction of emotional distress. As the court is aware, in order to be successful on summary judgment, you have to initially prove that you're correct as to the law and facts. Here, the initial prong was because there was no manifestation of physical symptoms, we cannot be successful on intentional infliction of emotional distress. But that's not what the law of Arizona says. So one of the issues with their motion as well is they failed to meet their burden of showing that there has to be a manifestation of physical symptoms. Because
here's what's interesting, and I'm going to interject. Objection, Your Honor. So Jane Doe's lawyer says that Greg Gillespie and his lawyer never shared proof that excuse me, let me say this again. Jane Doe's lawyer claims that Greg Gillespie's lawyer never met the burden of proof to share that there was not emotional distress. Am I getting this right? The judge had just said that the plaintiff's duty, because it's like the plaintiff has to prove that the evidence is there. And then Greg Gillespie's lawyer is saying, hey, you didn't show any reason whatsoever that this rash was linked to what could have been from him. I mean, she could have been at in a field and allergic to, she could have been allergic to pizza. I mean, who knows, right? Who knows what caused the rash, right?
But they alleged in their motion. And in their reply, it seems backtracked a little bit to just overall no severe emotional distress. But the motion itself was all about absent a manifestation of physical symptoms, plaintiff cannot prevail, which is inaccurate. And so my client would argue that they had failed to meet their burden, and so the burden never comes to my client to rebut that motion for summary judgment and to provide a genuine issue of material fact because they failed to meet their burden initially.
Okay, guys, I don't know. Again, let me know. Lawyers, please, let me know. The plaintiff's accusing the defense of not meeting the burden, even though it's a Clayton's job to have a burden. I'm going to be suing somebody for emotional distress just trying to listen to this stuff. Sarcasm.
I have to tell you, you lost me a little bit on that. It's okay.
So even the judge goes, "Hey, you lost me on that. I don't understand what the fuck you're trying to say here." Oh, funny.
Their burden in the motion for summary judgment is to demonstrate an absence of material fact. If they meet that burden of production under the standard of proof, which is by a preponderance, then your obligation is to point to or produce evidence that shows where the question of fact is, correct?
That's correct.
So the argument I hear you making is that because they relied on the absence of physical manifestation, that's enough. You don't have to then point to any evidence because they've not met their burden of production of proof, correct?
That's correct, Your Honor, because that's what they relied on. That's what the motion was based on.
Isn't it also based on I thought I read in there, it was also based on the nature of the injuries, not, because they're connected.
They are somewhat connected, Your Honor, but if you read through...
alleged anxiety, loss of sleep, that kind of stuff, correct?
And if I could just have one moment just to read this section of their motion,
Sure.
Your Honor.
Oh, boy. All right, so now he's reading some of the motion, and we're just going to talk to fill time here. But, I mean, look, guys, I could be way over my head.
The only reason I'm parsing it is because I need to understand what your position is.
Correct.
You don't want a judge to not understand what your position is. I think that's fair to say. If a judge goes, I don't even know what you're talking about. What are you arguing? So you have the plaintiff arguing that there is
I read through their motion, and this is subparagraph B, which is entitled, absent a manifestation of physical symptoms, plaintiff cannot assert a claim of intentional infliction of emotional distress. There is no argument in there that the actual emotional distress alleged was not sufficient. What they argue is solely throughout, they cite to one case and say courts have observed that mere emotional distress and severe emotional stress should be demarcated, indicate as a result of crying, being upset, that is not enough to establish severe emotional distress. But other than these two quotes or citations, the actual argument itself is all based on physical manifestations.
Okay.
As far as the damages issue, Your Honor, as I mentioned in argument regarding my client's motion on their claims, income claims and damages from a lost income claim and damages from the trauma suffered due to emotional distress are very different because there is no lost income which can be easily demonstrated by a paycheck when you're talking about trauma suffered by emotional distress.
What if there were a leave of absence from work and they go on family leave or anything? Not that happened in this case, obviously.
Right.
I mean,
but
it can be tied specifically to money, right?
It can be if that is what the claim is for.
Okay.
Here, it is not for lost income or things of that nature. It is for solely the trauma that was suffered. And I admit the wording was unartfully phrased in the damages section of the calculation, but it does state, and if I can pull it up here.
Am I going to be looking at your response or their original motion?
Thank you, Your Honor. I'm looking at their exhibit. So it is my client's disclosure statement.
Okay, hold on a second.
I have it right here if you want to see it.
I think I can. I know I have not have no credibility in my ability to go through this. Yeah, I'll take a look at it if you have it.
Yeah, Coach John?
Sure. Thank you so much. Okay, I'm looking, what page?
And we're looking at page 5, Your Honor, under subsection 7, computation and measure of damages.
Okay.
And so the second sentence in that computation and measure of damages indicates it is anticipated that damages will amount to at least $40,000 due to the trauma that Ms. Owens suffered. I admit that first sentence is, the combined effect of them is unartfully phrased, but this is sufficient to put them on notice that my client was seeking $40,000 due to the trauma suffered, not just due to cost and fees associated.
So they're arguing whether or not the $40,000 that Jane Doe is asking for is due to emotional distress or damages or both. And Jane Doe's own lawyer says it was unartfully described. I don't know if that means because she filed this herself or if he's talking about he filed it or a former lawyer did, but it's just messy. You can see if these cases aren't sort of don't have a solid foundation to begin with, how messy they become. It's like, what do you want the money for? Because you got a rash? Because you missed work? How can you prove that the rash was, you had to miss work because of the rash? How can you prove that the sleeplessness you felt was because of Greg Gillespie? I didn't get much sleep last night, but that's because I was scrolling TikTok when I could have gone to bed. You know what I mean? Like, what are we talking about here, folks?
What are costs and fees?
What are costs and fees?
The costs would be court costs and attorney's fees. And attorney's fees are not recoverable as a matter of right in a tort case. And I agree with that contention that they made in their motion.
So what we have here is Jane Doe's lawyer actually agreeing with the other side. He goes, look, I get it. She wanted $40,000 in part because of legal fees. And in a tort case, you can't recoup money for legal fees. So he goes, so he's almost working for the wrong side here.
Essentially.
And by the way, I don't blame him. I think he's trying his best given the circumstance. Okay. I always say this. I play baseball in a men's baseball league. I'm a pitcher. I'm only as good as my infield. I'm only as good as the team that I'm playing with. And I feel like the judge, I feel like the lawyer we could need some grace for him right now. He's trying his best. He's trying to solve a Rubik's Cube in the dark.
Or additionally, it is anticipated that it'd be $40,000 should have been added into this to make it more clear. Although I think when somebody says $40,000 due to the trauma that she has suffered, that's not just based on costs that have been paid out of pocket. And so
costs could not here anyway. We're not talking medical bills, those sorts of things.
Correct. That is not what is being sought. The only thing that is being sought at this time, and that would be sought in an arbitration hearing, would be damages for trauma, general emotional distress damages, rather than associated with any specific cost or expense.
Okay. Reply? Anything else?
No, thank you, Your Honor.
Your Honor, I'll just touch up on the damages portion of it. It was pled as the complaint says that she's seeking attorney's fees and costs, which is consistent with the notional disclosure statement.
Let me take a look at the complaint. It's in the complaint.
The complaint states that she checks off the box if she was pro se when she filed this.
Oh, that's right. They're pro se file.
It's pro se filing. Defendant or plaintiff's counsel could have supplemented and elaborated more, at least argued and said we are seeking general and special damages, which are the damages recoverable in injury cases. That's not pled here. But I don't think we get to that point because they don't meet their threshold to show that the emotional distress was severe, let alone they don't show any physical manifestation. It appears that the plaintiffs are arguing that we've waived the argument that there is no severe emotional distress because It's in a reply, and I think the court considers all the briefing.
But I think, candidly, it's inextricably tied to the question of whether there's a manifestation of harm. You're talking about the nature of the harm. Okay.
I agree, Your Honor. And there's no physical manifestation, but the injuries that she's claiming, there's no causal connection between the conduct that's alleged. That claim is not before the court. All of these symptoms were stated in conclusive fashion in the complaint pleading stage, but throughout this entire case, nothing's been elaborated, and it's been, we don't know if the court, and we can't determine if this rash is a symptom from Mr. Gillespie's alleged conduct. She could have a scratch or bruising, and she can say that's tied to the conduct. I mean, where do we draw the line? I think.
Is there anything in there about the date of the rash, when the rash was?
Where do we draw the line?
Or is it just a picture of a rash?
It was a photo of a rash, and I will note that
it says it has a time period on it, right?
I believe it does, Your Honor, but I note that we objected on the foundation because her affidavit does not state that photograph accurately depicts what is being demonstrated. So it's a foundational argument we raise, and I think the court, it's an objection that the court will, in my opinion, should consider because there's no foundation for that. But again, Your Honor, there's no physical manifestation. The case law is developing. I concede that point, but the most recent unpublished case that we've attached says that
the 2017 case.
Yes, Your Honor.
Yeah, I read it.
And in that case, Your Honor, the court cites to various cases and it says, well, typically in our cases, everyone suffers emotional distress.
You understand that case hurts your other case as well.
And again, Your Honor, at the end of the day, if the court were to dismiss in both cases, that would be a happy day for my client. It's been 2 years.
That's what I'm going to do, folks. There's not enough evidence of emotional harm from either side to survive summary judgment. So you're both.
So here's the judge saying, I'm going to dismiss both cases. So we have Greg Gillespie's lawyer saying, you just can't prove emotional harm here because of former court cases. And then the judge says, you understand that works against your rebuttal case where she's saying he's intentionally inflicted emotional distress on her. And then he's saying, no, you inflicted emotional distress on him. And the judge is saying, well, then I have to throw out both cases. And then Greg Gillespie's lawyer says, good, that's a win for my client if you will just throw this all out. We only filed this in response to her filing it on us. We don't want anything to do with her. We want to move on with our life. Is that a proper summary? I feel like that's my opinion on what I think we just heard.
Right, and you're both wrong. Class half empty, class half fill. I'm going to sustain the objections to the late disclosures. I'm going to grant the both cross motions for summary judgment. I further find that the damage disclosure made by the defendants in the case with respect to the fraud were insufficient in and of itself, and were insufficient for both the claims as well. And I find that the damages disclosure with respect to the plaintiff's claims following the court's because the court, in addition to the court's failure or decision that the late disclosure will not be considered, is also inadequate. Even if I were to consider both those filings, frankly, there's just not enough there for the court to find that it meets the standards of, and I looked at Midas Muffler case that you folks provided me. That seems to be the more, it's published court opinion, and it tells us what we need to be looking at. I will, who wants to give me, can you just work on a joint form just as to the... All
right, so then it ends right there, folks. So that's the lawyer, that's the judge saying, hey, no one wins here. If she can't prove emotional distress on you, you can't prove it on her. But how telling, re-listen to that part, how telling of Greg's lawyer to say, that's a win in the world for my client. He's been dealing with this for years. And then what happens after he's leaving the courthouse? Now, I don't have all the facts, but as far as I know, from sources I've spoken with, what happens after he leaves the courthouse and goes home, or maybe he wasn't there, maybe it's just his lawyer, I wasn't really sure. He finds out there is a new police report out on him from Jane Doe. And the beat goes on. Now, again, you're watching this far, you probably care, but this is what I'm dealing with. This is my livelihood. And I'm okay if people don't like my podcast, Bachelor Rush Hour. But these 1-star reviews quite literally make me sick. I want to sue this person for emotional distress. They left a 1-star review. You just copy Reality Steve and play other people's podcast clips. And so sick of the Clayton crap. Nobody cares. Boo-hoo. Shut the fuck up, okay? There's no better use of the term shut the fuck up. This is very important to the people that are involved. If you decide you don't want to partake in the consumption of this content, that's fair. But this is very important to the people that are involved. When does it end? When does it end? The judge said, I'm going to throw these cases out. Greg Gillespie's lawyer says, please do. Please throw our case out along with hers. Throw this whole thing out. We want to move on with our life. Greg Gillespie posts a photo a few days ago with his pregnant girlfriend. They're trying to move on with their life. They're trying to have a family. They're trying to do well for themselves in the direction of their dreams, one of the sort of core beliefs of this great country we live in. And they're being held back in the court system time and time again. And it looks like Clayton's next. And who knows down the line? Am I after Clayton? Or are we going to talk about this till they just pull the cord on the whole thing? That's the idea, right, folks? If you have any podcasts out there that you believe would be interested to hear this story, I'm happy to talk about it. I'm not in the court case. There is no order of protection against me. There is no gag order. There is no one telling me not to talk about this. And I will go on any podcast out there that has a following, that has a reach, that deals with true crime, celebrity news, entertainment news, any topic whatsoever that deals with defamation, lawsuits, harassment, or just wants to hear an interesting story. I'm willing to talk about this because it has to end. And sunlight is the greatest disinfectant, right? And we need to continue to talk about this. Not to inflict emotional distress on Jane Doe, but just to show that this stuff that plays out in the court system is ridiculous and it needs to end. Let me know what you think. We got more content coming your way. If you want to leave a 1-star review, please go to Bachelor Rush Hour. If you are sick of this Clayton crap, nobody cares. Prove her wrong. Do you care?